There you go. Okay, and Penny, the screen and the room is yours.
Thank you very much. That was a lovely introduction. Now I'll hit on this thing and hope that everything comes out. Okay, share screen. I did share screen and I hit on that. Let me see. Lynn, do you know anything else that I should be doing here?
So if you hit share screen and then you double click on your PowerPoint. There you go.
That's right. I only clicked once. I'm guilty of only clicking once all the time. Well, greetings, everyone. I wish that I knew who all of you are so we could have an interactive discussion, but Zoom does have some kinds of constraints on it. So I will just simply jump in because, as Lynn said, the Supreme Court is the gift that keeps on giving. There's huge amounts of things that one could talk about having to do with the Supreme Court, but we're going to keep this pretty narrow today. I'm going to be talking primarily about it's frozen. No, it's not. Yay, there it is. I got it. So today's presentation, we're going to just go over a few general facts about the Supreme Court, and then we're going to be talking primarily about the cases that came up in 2002 and particularly 2003. This is focused on 2003, but not all the cases, obviously. We're going to focus primarily on elections, executive power, the whole subject of race that is always with us and in our legal system, the environment and religion, because those are the major cases that the court took up last year and year after year after year. And then we'll talk of a couple of other topics at the end on the recent court scandals and the public response to those scandals and to what is going on the whole subject of Supreme Court reform. No, that's not working. So I want to start and talk about the defining feature of the Roberts Court, and that is different from many of the courts that preceded it. The Roberts Court started in 2005, so it's now 18 years old, or it will be 18 years old in October. And we have had during that time 17 different justices. If you look at the picture on the top, you will see a very young John Roberts sitting in the middle of his colleagues. And then if you look at the picture on the bottom, you will see an older man in the middle, still John Roberts, but everyone around him, with the exception of Clarence Thomas, is a different person. So this court has been characterized by constant change since the very beginning. I have never read a book about the Supreme Court in which this quote by Justice Byron White was not presented. When you change one justice, you change the whole court. It's simply a dynamic of the way these people work together. But prior to the Roberts Court, there were 11 years of the Rehnquist Court in which there were no changes in personnel at all. And that was, of course, followed by these 18 years of constant change in the Roberts Court. We have 8 new justices now sitting on the court, new from the time of the beginning of the Roberts Court. Some of those justices, the switch has mattered a great deal because they differed in their approach to the law and in their political beliefs. Others didn't matter very much at all because a person was replaced by another person who was very much like the original person. So I'll just run through these quickly, and I'm sure all of you would not be probably tuning into something about the Supreme Court if you didn't know who most of these people are. So Rehnquist obviously handed off to Roberts. That was not very much of a change. Both of them were very conservative judges. Then, very shortly in 2006, 1 year later, O'Connor left the court and was replaced by Alito. Of all the changes, of all the justices through the years, this is the biggest change in terms of the philosophy of the court. Justice O'Connor, of course, was a conservative Republican, but she was also the justice in the middle. She was the justice that could look on both sides, frequently voted with the liberals, sometimes voted with the conservatives, etc. She was influenceable by what she learned in about each case. Justice Alito is not that. Justice Alito is absolutely at the far end of conservatism. And you go from someone who is flexible and in the middle and open to someone who is not. Justice Alito, you have a huge change. Some people say that Justice O'Connor was the most powerful woman in the history of the United States because her decisions mattered so much. She was so much that justice in the middle that moved from right to left. And then all the 5-4 decisions in the court, she was crucial. Then we go from the change from Justice Souter, who left in a huff during Citizens United, and the person that replaced him was Justice Sotomayor. Souter was actually a Republican, but he definitely was a liberal. He voted with the liberal justices all the time that he was on the court. So changing from Souter to Sotomayor, who of course is a liberal as well, was not very much change. Then we changed from Justice Stevens retired, and Justice Stevens too was someone who was officially a Republican, but he was a very liberal Republican and voted on the liberal side. That changed to Justice Kagan, and she too was a liberal. So that was not much change. Then Justice Scalia very dramatically died. And we go from him to Justice Gorsuch. Scalia and Gorsuch are very much alike. They are both textualists, originalists, very conservative justices, and also they have personality traits that are very much in a little bit of, shall we say, I don't want to use the word arrogance, but nonetheless, they're both very, very confident of themselves. Then we come to Justice Kennedy and handing off to Justice Kavanaugh. And that was, Justice Kennedy was also considered to be a, quote, justice in the middle. He wasn't nearly as much so as O'Connor, but nonetheless, he was flexible in terms of which way he leaned from time to time. And it was viewed that Kavanaugh was not going to be, that Kavanaugh was going to be conservative. Kavanaugh has turned out to be a very interesting justice, as we'll see when we're going through the cases. Then we have another big bomb that drops, and that, of course, is the death of Ruth Bader Ginsburg and her replacement by Justice Barrett. Justice Barrett is very much a conservative justice, and Justice Ginsburg was as liberal a justice as there was on the court. She was the leader of the liberal wing of the court for many years. So that, too, is a huge change. And now, just in this last year, we have Justice Breyer, who just retired, being replaced by Justice Jackson. And there's not a huge amount of change between the legal or political philosophy of those two justices. So the only justice that is now still sitting on the court, as I said, is Clarence Thomas, and he is likely to stay there for many years. The court is now polarized 6-3, and pretty much people stay in their lane of being either conservative or a liberal. There's not a whole lot of going back and forth, although there are a few, and we'll be talking about at least one in these cases. We don't have a justice in the middle anymore. We don't have a justice that you can depend on to be sort of really open-minded in all their approach, and nothing on the order of Justice Kennedy or O'Connor. So just a few little random facts about the court. Under the Constitution's Article 3, which of course is the shortest article in the Constitution, less than 400 words, you might even call it skimpy. All federal judges are to be appointed by the president and cleared by the Senate, and we're all familiar with that process. Once they have been approved, however, and sworn in, they have lifetime tenure, and they cannot have their salaries cut. It says so in the Constitution. Their salaries cannot be cut. This was a part of protecting them as being, quote, the weakest branch of the government. It is very interesting when they can be impeached. I frequently get asked, can a justice be impeached? One justice was in 1803, and it hasn't happened since, and it isn't going to happen again, probably. One of the more interesting things that a lot of people don't know is that The United States, in its Constitution, created the very first Supreme Court. Many other nations have created Supreme Courts since then, but there was no Greek Supreme Court and there was no Roman Supreme Court. We had the first one in the history of the world that we know of. But of all the countries that have followed along, and most countries now have a Supreme Court system, no other country has chosen lifetime tenure for their judges. No other country in the world. Most countries either have term limits or they have mandatory retirement ages, one or the other. But a lot of people took a look at our system and said, nope, too much power in the hands of people for too long. So another important point is that all of the court decisions are made by majority vote, taken in seniority order. Everything that the Supreme Court does, whenever the group is together, is done in seniority order, and everything is by majority vote. In other words, although Roberts has a lot of extra responsibilities because he is the Chief Justice, he has almost no real power in things that matter. He is one vote of 9. That's it. He doesn't get special treatment when it comes to the most fundamental job of the court. Another thing that a lot of people don't know, but that matters enormously, probably matters every bit as much as the decisions that the justices make that hit the front page of the Washington Post. Roughly 6,000 cases are proposed for consideration by the Supreme Court every single year, 6,000 different cases. But only 1%, 50 to 70 cases are selected by the judges to be heard. So that judges have enormous power over the national legal agenda, because you can make something really important by not doing it. In other words, if there is a particular kind of case and that could have great national impact that the justices don't want to touch with a 10-foot rod, they have every power to just simply say no, and that case goes away. So why do they pick what they pick? There are lots of different reasons, obviously, and most of the time we have no idea, because this is not an organization that is in any way open in terms of what its thought processes are, except in their opinions and their dissents, and sometimes they write books. But other than that, in general, and the occasional speech, they're giving speeches more than they used to. They used to almost never give speeches. So you don't know what's going on in the Supreme Court very much. But the justices are interested in certain subjects, and we see that every year when they make their choices. A recent example is a dramatic rise in the religion cases that they have accepted. In June of 2022, they actually made decisions on a record. 6 major religion cases were decided in June of 2022. That just has never happened before. Dobbs was only one of those cases, Dobbs obviously being the overturning of Roe v. Wade. It was the most famous, but it was only one of 6. And also during COVID, from 20 to 22, numerous emergency stays of various kinds of state, federal, and local orders were touching on religion. And the Supreme Court absolutely picked them up and ran with those cases over and over again. There is a desire also on the part of many of the justices to strengthen some new, quote, doctrines that they are coming up with. There are more new doctrines introduced to the Roberts Court and by the Roberts Court than there have been in the past for a very long time. Doctrines don't come along very often. Every 10 years or so, you get a new major doctrine. But with this court, they have come along more often. And we are going to be talking about the major questions doctrine, which they have now raised 3 times in the course of 1 year, and it's a brand new doctrine. So it's something they're obviously very interested in. There's also a need to make time for the increasing number of shadow docket cases they have. I'm sure some of you have heard that term, shadow docket. These are cases that don't come through the normal procedure up the chain, but cases that arrive at the court. They say we're an emergency, you must make a decision right now. generally those were turned away in huge numbers, and we mostly associate them with someone who's about to be put to death the next day, and they ask for an emergency consideration by the Supreme Court. But these are on much broader subjects than that. And the Supreme Court still starts the first Monday in October, and it still ends the end of June. So they haven't got any more time than they used to have. And these shadow docket issues are taking more and more of that time. And they may have a desire, and it's certainly understandable, to overturn and control the lower courts. In the last few years, the Supreme Court has, of all the cases that they have overturned 83% of the lower courts. So if your case goes to the lower court, goes from the lower court up to the Supreme Court, you can pretty much bet that it's a high probability that it may be overturned. So this is the room they live in. They each have their own chambers, of course, which is a suite of offices in the Supreme Court building. But this is where they meet, and you will notice that there are 9 chairs around the table. Robert sits down here at the end and looking at the fireplace. And then in seniority order, back and forth across the table, we go down to the newest justice, who is sadly sadly for that person, I would imagine, given the job of taking notes for each one of these conference meetings that they hold. And they meet in conference on average once a week. No one knows exactly how long these things are, because the most important thing is that although you see 2 chairs by the fireplace, nobody ever sits in them, because they have no staff, they have no clerks, they have nobody but the 9 of them, week after week, after day, after month, after decade, 9 people sitting in a room. And this sort of explains why, if you have a change in the Supreme Court, it makes so much difference. They work in a sort of 1-on-1 or 9-on-1 kind of atmosphere all the time. And so one person changes in that group effort, and it makes a difference. So now we'll go to the cases. In 2022, this was considered to be a blockbuster year by any measure. It was one of the most dramatic years in the history of the Supreme Court, and certainly in the history of the Roberts Court. They took up the first major gun case in 15 years. I think many people are familiar with the Heller case, where they decided that every American had a right to have a gun in their home for personal protection, and that this was a constitutional right. In this new case, the Bruen case, they decided that Americans also had a right to concealed carry, which means you have a constitutional right to have your gun about your person, no matter where you are, with few minor exceptions. And in addition to that, Justice Thomas, who is the most ardent pro-gun person on the court, established, although it was really part of this case, but he established new criteria for state and local governments that basically said that state and local gun regulations had to be in conformance with whatever was the appropriate law in, of all things, the 18th century. And so we actually have cases moving through the system now. There's one in the state of Maryland. State of Maryland requires background checks in order to get a permit. This is now being challenged in court because there were no background checks in 1789, which is stunning when you think of that this will now be our criteria in this year in which we are having a blistering year of gun issues come up. It's amazing. But nonetheless, that happened last year. There was also West Virginia versus EPA, which eliminated EPA's authority to regulate greenhouse gases in any other manner other than just giving a permit to each facility. In other words, the most, shall we say, non-universal approach you could possibly take greenhouse gases. And it was also the very first time the Supreme Court mentioned the new major questions doctrine. And the major questions doctrine has become a major issue, as I said a few minutes ago. In presidential power, there are always presidential and executive power cases that come to the court. Federal COVID rules were approved. Government put out federal COVID rules for any facility that was taking Medicare patients or Medicaid patients. And the Supreme Court, that was challenged in court by people who were opposed to shots and masks and things like that. And that was challenged in court, but the court said that Medicare and Medicaid are federal programs, and therefore they had a right to have standards. But they disapproved of the rules that were put out for private industries, for people in industrial settings to have to comply with various kinds of COVID protections. And finally, in the presidential powers area in 2022, they released Trump's presidential papers to Congress, because that had gone all the way up to the Supreme Court as to whether Trump had ownership of his own presidential papers. And everyone thought that would be a 9-0 because he doesn't. By law, the law is very clear in this area, and all of the presidents have handed over their presidential papers when they left office. But it became famous and controversial because you'll note there that the vote is 8-1. It was not 9 votes. And the one was Clarence Thomas, whom everyone knows his wife had obviously a major interest in Trump's reelection. So the fact that he said, no, Trump shouldn't have to give his presidential papers, became very, very controversial. And then there were, as far as elections were concerned, numerous emergency kind of cases arising from the 2020 big lie about the Trump losses. And all of those cases that went up to the Supreme Court were turned away from the Supreme Court, and they didn't take any of them. Okay. The most interesting thing, though, about last year's cases, we're still in 2022, we haven't gotten to 2023 yet, were the religion cases. As I said, there were 6 major cases. One of them was an 9-0 unanimous case, minor case. But the other 5 were very, very not minor. The Dobbs case overturned Roe v. Wade, and it overturned the Casey, and it changed abortion in this country, who knows, probably forever. And they allowed the Mississippi law that banned abortion after 15 weeks to go into effect. Before that, it was 24 weeks. And so by overturning Roe and banning any abortion after 15 weeks, making that perfectly legal, that was the blockbuster case of last year. As far as the shadow docket was concerned, having to do with abortion, they also allowed Texas to have a 6-week abortion ban, no abortions in the state of Texas after 6 weeks. And they also allowed the very draconian vigilante enforcement mechanism. Perhaps you remember $10,000. You could get $10,000 from the state of Texas if you found a person who had assisted a woman in getting an illegal abortion. And literally, it could be a taxi driver that drove her to the office, to the doctor's office. And it certainly could be any doctor that did that. $10,000 bounty given to anyone who found somebody who had broken this law. Very, very Texas-like. And then we, of course, had a case in which the state of Maine, which has a lot of very rural high schools, had a funding program for high schools, but they didn't give money to religious schools, because that has basically been banned for years in separation of church and state, that the state does not give money for religious education. And this was overturned by the Supreme Court and the state of Maine, and by extension, any other state that has funding of public school programs will be required to extend that funding to religious schools as well. This is still the definition of all the ins and outs of this are still very unknown, but nonetheless, this is a major change in the relationship of our religion and our schools. In a similar way, this case, Kennedy versus Bremerton, also allowed a public high school coach to pray on the field and lead his young men in prayer to play on the football field, and of course in the locker room, as the free expression or free exercise of his faith, as opposed to imposing the separation of church and state. Once again, the public officials do not do that kind of thing. So all of these were very, very, very important and big deal cases. So we have now gotten to 2023, which is largely the cases that came out just last June, like 2 months ago. Some of them came out a little bit before that, but in general, the Supreme Court releases all the big cases, the important cases, at the end of the year. These are just the names of the 5 that we're going to talk about. They are very important cases. Moore v. Harper. This is the independent state legislature theory. That was considered the most important case of the year. In the racial area, we had the Supreme Court overturning affirmative action in the students against Harvard for fair admissions versus Harvard, North Carolina. In the executive power area, we had Biden versus Nebraska, which was the whole student loan forgiveness issue, the $10,000 or $20,000 forgiveness of student loans. In the environment, we had Sackett versus EPA, which was a complete redefinition of the whole meaning of wetlands and the whole deregulation of thousands of miles of wetlands. And finally, in the religion area, we had religious free speech versus gay rights. And we'll talk about each one of those in some detail because they are the new ones. Moore v. Harper was a 6-3 straight up conservative liberal decision and was considered, as I said, the most important case of the year. In this case, the issue was something called the independent state legislature theory. This is another one of these doctrines that are being put forth. The Constitution, Article 1, Section 4, gives state legislatures authority to run federal elections. It's couched in the Constitution as they can set the times, places, and manners of federal elections, not just state elections, but federal elections as well, which is why all 50 of our states have different kinds of state rules and regulations for carrying out elections that are national elections. Congress can alter that by law. The Constitution says it can, but Congress rarely does. We could have a more uniform structure if Congress were to do that, but it just doesn't take on that hot potato. So like many things, the Supreme Court is here being, shall we say, more aggressive than our legislative body, the Congress, which is supposed to be the sort of center of our government, since it is the way we, the people, are represented. But nonetheless, in this particular case, the Constitution says times, places, and manners are set by the states. And more specifically, it uses the language state legislatures. That's the language it uses. So what this case was about was a gerrymandered, we have the maps redrawn once every year after the census is taken for all the states in terms of congressional representation and in terms of state legislatures. So new maps get drawn every 10 years, and many of them are gerrymandered, meaning they are arranged so that the party in power gets a lot more Congress people than the other people do, than the other party gets. It's a kind of cheating, if you will, if you truly believe in representative government. It's a way to make sure that your representative represent your ideas as opposed to the other guy's ideas. But these maps were overturned by the state Supreme Court, not the federal Supreme Court, but by the state Supreme Court of North Carolina, based on the state constitution, which said that the maps must be representative. It's in the Constitution, and the state court put it into place, even though the legislature had created a totally gerrymandered map. Basically, North Carolina has roughly half and half Republicans and Democrats. And I think the Republicans had 80% of the congressmen. So obviously this was not very representative. The opinion that the court came out 6-3, an unusual 6-3 this time. This is interesting. The opinion was written by Roberts. It was a rejection, complete rejection of this theory. And he was joined by Kavanaugh and Barrett and all three of the liberals. So you've got 3 conservatives and 3 liberals saying, hell no, this won't go to the state of North Carolina on this subject of gerrymandered maps. What they actually wrote was, what Roberts wrote in this opinion was, the Constitution does not give state legislatures the authority to ignore state constitutional limits. North Carolina Constitution said you have to have representative maps, or state courts when these legislatures write the law to govern how federal elections will run. So the conclusion we have from this particular case is that it's great that they killed off this theory, because it could have been very, very dangerous as a precedent for many, many, many other states. But the bottom line is that conservative state legislatures are still firmly in the driver's seat on federal elections. And we can see that very easily here. This is a chart of state legislature populations and which party controls them. All 50 states are on this chart. And as you can see, if this chart had actually stretched back into the 80s and the 50s, et cetera, most state legislatures were Democratic for years, for decades. But in the great switch that happened 2 years after Obama was elected, Democratic state legislatures dropped like a stone and Republican state legislatures took over. So you now have a situation, and this goes all the way over to just last year, 2022, where the Democrats haven't broken 20 state legislatures in all that time, and the Republicans have remained pretty much in charge of the whole state legislature function, having one side or the other side of 30 legislatures in the country. There are still a few legislatures that are split, where their House and their Senate is one's Republican, the other's Democrat. But for several years, there was only one state in the whole country that had that split. Now there are 3 as of the last election. But what you really have here is party control by the Republican Party of state legislatures. And that means that they get to write the rules for federal elections. And that is why this whole subject is so important. Okay, and I hope if you have any questions about any of these, you'll jot them down and we'll talk about them at the end, because I'm going through this pretty quickly and I know it's a lot to take in. I apologize, but it's hard to make this stuff really as simple as you would like to have it be when you're talking about it. The next subject that came up just last June was the Students for Fair Admissions versus Harvard and University of North Carolina. Once again, this is a straight up 6-3 decision. And this was the end of affirmative action in both public and private education. It's gone. Affirmative action is gone. The Roberts opinion said that the student must be treated based on his or her experience as an individual and not on the basis of race. Justice Thomas also wrote an additional opinion. Sometimes you get more than one opinion. It is agreeing, but it's bringing up a different point. And he stated that we have to have a commitment to a colorblind constitution that crosses everything. The colorblind constitution is the constitution that we have. Now, of course, Roberts very definitely, Thomas very definitely was an affirmative action student. Both he and Justice Sotomayor both came into the good schools they went to because they were chosen through an affirmative action. Thomas went to a very poor school in rural Georgia, and Sotomayor went to a terrible school in the Bronx. Both of them did go to Catholic schools, which were much better than the public schools, started out in the public schools and then went to the Catholic school. Nonetheless, they did not have the kind of education that gets you into places like Princeton. But Sotomayor went to Princeton, and Thomas, I believe, went to Notre Dame, and both of them made it big time. They got great grades. They got great jobs when they got out. They both got into Yale University, Yale Law School. So, but Thomas came out with a really oppositional, he hates affirmative action, whereas Sotomayor defends it as being enormously important. So Sotomayor, in her dissent, and of course she would be the one to write the dissent in this area, said that the majority's version of race neutrality will entrench racial segregation because inequality will persist as long as it is ignored. Now, so that's basically it as far as I'm sorry, I knew there was another slide there. There is more to say about affirmative action. Whereas there was a huge reaction to the abortion issue on the part of the liberal community and also on the part of America in general. I think last number I saw was 72% of Americans believe that a woman should have a right to choose. However, those numbers are nowhere near like that on the subject of affirmative action. The Pew survey of June of 2023 on affirmative action in college admissions said that 50% of American people disapprove of affirmative action as a concept. Only 33% approve and 16% are unsure. Every poll I have ever seen of how people feel about affirmative action in the United States has a huge unsure segment because, and I think this is true for most people, there are some situations in which it's a good idea and other situations in which it's probably not necessary at all. So people they don't have a black and white view of this issue. Sometimes they think it's good, sometimes it's not. But in general, we already have 9 states that already have bans on affirmative action for selecting student bodies. And as you can see from this list, many of them are quite liberal states. California, Washington State, both very liberal states, but they ban affirmative action in student selection. And recently this was reconfirmed because in the year in which Biden was elected, 2020, where there was a huge turnout in the state of California, there was a proposition on the ballot to eliminate the existing state constitutional ban for affirmative action. And it went down to defeat, and it wasn't even that close. It was 53 to 47. So in a year of a huge liberal surge in California, you have affirmative action shot down yet again. So it's unlikely that we're going to get anything like the response that we got on abortion. There is a question as to whether this will have a chilling effect on a lot of the private employment sectors. Many corporations have a goal to actively have a diverse workforce and have been very successful in bringing forth a diverse workforce. So we'll just see how the private sector of the non-education sector responds to this decision by the court. There has already been one major backlash, however, and that is there has been an intensely negative scrutiny of legacy college admissions. Legacy college admissions mean if your mom and dad or your Uncle Joe went to Harvard, you've got a pretty good shot at getting into if your grades are even halfway decent. And obviously, these legacy college admissions overwhelmingly favor wealthy white students. And so if what you're talking about is you're against affirmative action because we should have a meritocracy, a pure meritocracy system, this whole legacy business is really not something that we should be allowing. So now we come to Biden versus Nebraska, which is 6-3, the usual 6-3, conservatives and liberals. And this was the president wanted to use the authority that was found in the 2003 HEROES Act to forgive federal debt. And I'm not going to go into any detail because I'm sure you're all very familiar with this. Roberts' opinion could have been limited by simply saying that that law only authorized them to waive or modify the rules during an emergency, and the emergency's over. I mean, he made that point. But then he goes farther to once again bring up the major questions doctrine. And the doctrine is stated thusly: an agency of government must have clear statutory authorization to act on issues of, quote, vast economic and political significance. Now, who is going to decide which laws have vast economic and political significance? Where is the criteria for that kind of language? And of course, everyone said, and everyone is right, Congress won't do that. And so, in all probability, it will be yet more power given to the Supreme Court. And there have been a lot of articles in the press and in learned journals, et cetera, that the Supreme Court is amassing power that no one ever originally dreamed of. Kagan, in this particular case, and if you're ever going to read a dissent that is clear and understandable and really passionate, Justice Kagan wrote this dissent, and it was put out just a few weeks ago. The majority blows through the guardrails intended to keep courts acting like courts. From first page to last, today's opinion departs from judicial restraint. In other words, she's saying this deciding that large issues of vast economic and political significance have to be specifically authorized by the Congress, and therefore, and not saying anything about the existing law, the existing Constitution. This is new. This is saying Congress has to tell people if they're going to spend large amounts of money. And no agency can spend large amounts of money unless Congress has said so. Now, this could bring the whole regulatory structure of the United States to a grinding halt over time. So what she's saying is that the Supreme Court has gone way beyond its normal bounds of interpreting the law and has extended vastly into areas of policy. She ends with, the court exercises authority it doesn't have, and this sentence of 4 words is really a bombshell. It violates the Constitution. In other words, she is saying a decision by the Supreme Court violates the Constitution. And this is these are fighting words. And Justice Roberts was quite angry and said so in his response to this. So then we have, and I'm trying to leave as much time as I can here. Forgive me if I'm going pretty fast. Sackett versus EPA, which is basically the issue of what is the definition of a wetland under the Clean Water Act that was passed in 1972. So it's been in place and it's been operating for 50 years. And the Alito opinion changed words that had enormous impact. And I won't go through what all of this change means because it would take too much time. But basically, Justice Kavanaugh joined the three liberals against this decision. And he said that changing this definition of what wetlands are in the United States of America would cause the loss of land the size of California, square miles by the millions, in terms of the amount of wetlands that are presently regulated that would not be regulated given this decision. He wrote that it would require major adjustments to state and local regulation literally everywhere, and on other subjects such as flood control and all that's about to happen vis-a-vis climate change mitigation, that if this just has enormous impact on the amount and the regulatory structure of water bodies in the United States. And Kagan went on to say that the court should not make these kinds of decisions. Once again, it's going beyond its mandate. Congress purposely left them to technical experts because average congressman's got like 15 people on his staff. He doesn't know how to tell you what is and what isn't a wetland. So you need experts that can do this in the government. So the court should not make these kind of decisions, she said. Congress purposefully left them to technical experts and compared this to the curtailment that I was just talking about the year before when they cut back on EPA's ability to regulate greenhouse gas emissions as well. So this is a water issue. Last year, it was air. So finally, and this is the last case, is the case of the religious owner of a company that wanted to refuse to make wedding websites for LGBTQ couples. She went to the court before she did anything, and that's supposed to be beyond the rules, but we won't get into all of that. What she was saying was, I am going to be tagged by the Colorado Public Accommodations Law that, like most accommodations law in the United States, prohibits a denial of goods and services based on race, creed, disability, sexual orientation, and other traits. In other words, you can't, if you are in business before the public, you cannot discriminate against these protected classes. Again, a 6-3 decision, conservative liberal split. And Gorsuch wrote this opinion. He said, the state cannot force her to convey messages inconsistent with her religious beliefs. And so her religious beliefs trump the right of a person who is LGBTQ from that community from getting website services, even though it will be open to everybody else. So this draws a very strong line between the Second Amendment free speech rights and past course precedents that upheld the public accommodation rights of protected classes like races, sexual orientation, creed, etc. Justice Sotomayor wrote a dissent that for the first time in its history, the court grants a business open to the public a right to refuse to serve a member of a protected class. So another, we've got a whole bunch of, I have another bunch of cases, but we're not going to go through them because we don't have time. I want to make only just 2 more points and then we'll open it up, I hope, for some questions. Alexander Hamilton, who wrote this particular part of the Constitution, was absolutely wrong. He defended it in the Federalist Papers. And what he said in the Federalist Papers was that the Supreme Court is a weak and powerless institution that requires the protection of lifetime employment appointments. He is defending the decision to have lifetime appointments because it's such a weak sister compared to the Congress and to the presidency. Altering a court major rule at the beginning of Biden's presidency was on the docket. And within a month after Biden became president, he decided that something had to be done about the Supreme Court. But since then, it has been much more fervently, fervently is an issue for the population in general, because of the Dobbs decision and everyone's negative reaction to the elimination of abortion rights, and more recently, just within the last few months, the scandals of Thomas and Alito, all of this has made the country think we ought to change this system. And it's surprising how many people do. The Supreme Court's approval rating dipped below 40% for the first time ever in 2022, and it has remained there this whole entire year. So the question is what to do about that declining respect for the Supreme Court and its decisions. Well, Biden did set up a commission, the President's Commission on the Supreme Court Changes, and they had 4 meetings, and they were asked not to make recommendations, but to essentially identify the major alternatives that would be there to change things in terms of the way the Supreme Court operates. So there were 34 members actually there were 36 to begin with, 2 people resigned, and they all unanimously presented their report at the end of 2021. And essentially it came down to this. There were 2 proposals, alternative proposals, and there was total disagreement between the various members of this commission. There was no consensus whatsoever. The liberals wanted court expansion. They wanted to add people to the court. The conservatives wanted the status quo and make no changes whatsoever. And academics and a lot of quote thinkers and intellectuals wanted term limits. So it was basically a third, a third, a third. So they made as no recommendations. But there has been a recent poll, and there has been a lot of talk about the Supreme Court and its need for change. And this poll that was just at the end of last March shows there's a real evolution in public opinion. 68% of the American people, according to this poll, want term limits specifically. Only 30% support total justice discretion on their retirement, which essentially in the system that we have with lifetime terms means that you have the justices are the ones who call the ball in terms of when they're going to leave, and they only do it when they've got a president in place that they like. So not only do they get to stay in the court for 30 years, but then they get in a way to pick their own successor by leaving when they have a president that they know will do it the way they want it. So the American people now want change, and there is simply no doubt about that. And that was the case 150 years ago. And Abraham Lincoln, as always, I like to end this way because I think he's such a marvelous wordsmith about deep truisms about our nation. In this age, in this country, public sentiment is everything. With it, nothing can fail, and without it, nothing can succeed. Whoever molds public sentiment goes deeper than he who enacts statutes or pronounces judicial decisions. And I think at this time of polarization between Republicans and Democrats, between conservatives and liberals, this is a real problem for the United States of America right now, because we don't have any kind of unanimity on public sentiment that we can look at. So I'm done, and I would love to take some questions. I do want you to know that if anybody is interested in having these slides, if you send me an email, I would be more than happy to send them to you. I do them 6 slides on a page, and it's black and white. And if you do it back and front, it's only 2 pieces of paper. So it's not as long as it might look. So if you would like copies of them, please let me know. In the meantime, what do we do now, Lynn?
Okay, so Penny, wow, you certainly covered a lot. I can't
imagine people's ears are falling off at this point.
So the first thing I'm going to do is ask you to click the stop sharing. You said on your computer it's on the top.
Stop share.
There you go. Okay, so now you can see people who might have questions. And I'm now going to open the room for questions. Please remember, everybody, that you are muted. And so if you'd like to ask a question, you need to unmute and I will recognize you. Let's see if we have any questions. Everybody's head is spinning because you covered so much.
Yes,
But
I'm sure it is.
well, I
We-
mean, but it was phenomenal information, truly, truly phenomenal. Do we have any questions? Anything that
We have 26 participants. Surely somebody has a question.
Let's see. I see people.
Yes, sir, Michael.
Yeah, Penny, you had mentioned that the court takes only 1% of the 6,000 cases that they could consider. How do they determine which cases to take? Is it unanimity, a majority?
It is, you have to have 4 votes to take a case. But if you want to win it and you have a point of view, you have to know that you can get a fifth. Because it's got to have 5 votes in order to prevail. So in general, cases are taken, they know what they're very likely to come out with in the end. They choose the cases that they want to take and that they believe they can win in their point of view. How they make those decisions, there's only one major criteria where they have to take a case. And that is if there are 2 circuit courts in the country, a circuit court in Boston, say, and one in Texas, that have decided essentially the same thing or looked at the same issue and come to different conclusions. In other words, you've got different law going on in Boston than you do in Texas. Then the Supreme Court has to take those cases because we want to have law, federal law in particular, that is the same across the entire country. And so that's a criteria they must meet. Other than that, they can have almost any justification they want to. And that's how they turn down, what is that, 5,000, to say they took 50 cases and 950. So that is a lot of cases to turn down. Now, there is a court process that goes through all these cases, and there are many that are just simply never going to make it. They don't deal with big issues. They're very much private things that people want to take it to the Supreme Court so they can win, but they're not of any national import. And those get pushed to the side pretty easily. They can cull through those. But they meet to cull through these ones that are recommended by their clerks 2 or 3 times a month, because 6,000 cases pouring in the door all year long, you got to deal with a lot of them. And a huge portion of their time is spent on this, picking cases for either this year or next year. And I don't think the public thinks of them as sitting on the dais and reading briefs from all sorts of people, but they spend a huge amount of time on this culling through cases process. And the public just doesn't know about it.
So Penny, somebody put in the chat that they love the presentation and they're looking ahead. They're wondering, do you have a sense of big issues coming before the court, or is it not possible to know at this time?
Well, there are a few cases that they've already accepted that we know are big issues. One of them is this gun case that I just mentioned. I don't know whether they'll pick that one, but you have essentially Thomas's new criteria for what is acceptable and not acceptable for gun regulation on the state and local level has caused every state and local government that has gun regulations get out the book and look at it and see what they think will apply, because it was being done in the 18th century. And that is going to be a huge issue. They've already taken a case on, there is a federal law against people who have committed physical violence against other people. They are not allowed to own guns. That's a federal law. And that was reconfirmed by the Roberts Court about 5 years ago. And now they're going to take it up again, and everybody thinks they're going to throw it out. So the people who are convicted of domestic violence in particular will be able to buy guns again in this country because they were able to do so in the 18th century. It's an almost bizarre. That one, I think, is is so strange that there may be some congressional pushback on that issue. Congress can still pass laws. They don't very often, sadly, but they can still pass laws that control things. I mean, Congress can decide that there is a national right to an abortion. They can decide that, or the other way, that there isn't, that there's a national right not to have allow abortion. But Congress is becoming such a weak link in the chain that more and more decisions are shunted off to the Supreme Court. And that is why we have these kinds of decisions being made year after year after year. And with the new 3 Trump justices, more and more of those kinds of decisions are coming, is accepting them. Michael was just talking about.
You look so pretty in your pink, Jenna.
Got it. Thank you. Any other questions before we wrap up? Okay, so Penny, thank you. This was absolutely incredible. You did a phenomenal job, and I really, really appreciate it. And I know that we will love to have you back and see the next rendition of your talk. I just want to remind those of you who are on that our CCC programs, Cocktails, Conversations, and Community, are always open to the community. And our next one is scheduled for September 27th, when we will be talking about adults conquering technology. So Penny and I did a great job and didn't have problems with technology, but I know some of you do. And so
I'm going to tune in for that one for sure.
well, you're welcome to come back and join us. And so please mark your calendars. That'll be September 27th. And we look forward to seeing you then, and enjoy the rest of your summer. And Penny, again, thank you very much. And Michael, as always, thank you for arranging these.
Thank you for having me. I enjoyed it.
Great. Well, have a nice evening, everyone.